The petitioner before your lordship, and his associates for their unlawful and illegal gain in connivance with the landlord, Mr. Vinod Rampuria, must have forged and fabricated various documents in order to transfer or surrender the tenancy right of the office as to transfer the office of the company, as it would otherwise be impossible to put effect to the same legitimately. So, my lord, the allegation of forgery here is presumptive. That since you have shifted the registered office of the company, therefore you must have or you might have committed the offense of forgery. আর এটাও ফ্ল্যাগ করে দাও এই জায়গাটা 210 এই জায়গাটা 201 এই জায়গাটা একটা ফ্ল্যাগ এই জায়গাটা লর্ডশিপেরটা এখানে করে So this is presumptive, my lord. Now what was presumptive in FIR, my lord, can be accepted. Now apropos this, if your lordship sees now the charge sheet, no single document has come out showing forgery. I think charge sheet is at the beginning of this, my lord, the case diary. Your lordship will see, my lord, the paragraph in the charge sheet where, my lord, the description of the document is mentioned. No single document. So therefore, my lord, which was his mere apprehension, never turned to be true. No evidence was garnered by the investigating agency in order to bolster that allegation, my lord, to corroborate that allegation.
In respect of surrender of the office.
Right. So there are, so for forgery, my lord, he has two counts. One, Form 32, which he has accepted that he has signed. Number two is surrender of tenancy. Now, surrender of tenancy, my lord, he said you must have done something. Otherwise, you could not have surrendered the tenancy and changed the registered office. But nothing oozed out during investigation.
So, allegation in the FIR on two counts.
So, for forgery.
Forgery,
right?
That is, we have forged. Otherwise, you
could not have shifted.
Could not have
right, my lord.
Withdrawn. Therefore, you must have forged
some documents.
And second is that one is surrendered, and another is
filing of Form 32 and my induction as a director.
Form 32 is though I put my signature, it was
but without my consent and without any permission, without taking permission from BIFR, you have utilized it. My lord, I will request your lordship, my lord, I will rather entreat your lordship to quash this proceeding only on the ground of suppression, my lord. But this is magnum fraud. This has not only, my lord, deeply injured the majesty of this institution, my lord, this has made a mockery of rule of law. That I suppress everything. I participated in criminal proceeding, in other collateral proceedings, but I withhold that fact, my lord, consciously. I don't mention anything in the FIR. Let the police machinery get activated. Then there will be a thorough investigation. There's a charge sheet filed. And what police did, my lord? But the first thing, what I was just arguing before your lordship, I'll learn from your lordship when your lordship was taking up, my lord, division bench matters, my lord, criminal appeal. In a 302, if somebody cries out, there was murder, then the first thing police has to do to ascertain the dead body. No, you don't know, you don't check up the status of the order that was stayed by the Honorable High Court. Despite the fact that in response to the notice under 41A, we have mentioned all these facts. And those documents are before your lordship, my lord, not only in this petition, in the case diary only. Now, my lord, on that score, I will request your lordship, my lord, that since the investigation is faulty, on that ground also your lordship can pause this proceeding. Apart from other grounds I have.
Charge sheet submitted.
Charge sheet submitted. Now, my lord, I place, my lord, this judgment I have learned from your lordship, my lord, just for your lordship's ready reference. My lord, I have given a compilation. Only two more judgments I will be placing, my lord. One, my junior insists me to file it, rely on. And the reason I will tell your lordship when I will be placing that. And the second one is, the first one is this one, my lord, H.N. Risbooth, AIR 1955, Supreme Court, 196. My lord, I have flagged the relevant portion, my lord, with your lordship's leave. At page 201. But this dispute is a locus classicus, your lordship knows, my lord. But I have flagged that question your lordship has got. It starts as thus. I'm obliged, my lord. Thus, under the code, investigation consists generally of the following steps. 1. Proceeding to the spot. 2. Ascertainment of the facts and circumstances of the case. 3. Discovery and arrest of the suspected offender. 4. Collection of the evidence relating to the commission of the offense, which may consist A. Examination of various persons, including the accused, and the reduction of their statement into writing if the officer thinks fit. B. The search of the places or seizure of things considered necessary for the investigation and to be produced at trial. And 5. Formation of the opinion as to whether on the material collected there is a case to place the accused before the magistrate for trial, and if so, taking necessary steps for the same by filing a charge sheet under section 173. The scheme of the code also shows that while it is permissible for an officer in charge of a police station, the next part will not be relevant. So, my lord, the last and penultimate part of an investigational proceeding is formation of opinion. Now, my lord, with deepest respect, what I have learned from your lordship, charge sheet is the result of an investigation. It's a mere opinion of a police officer. My lord, how can that opinion be formed without considering the relevant materials, my lord? If that is so, then the opinion is faulty. As a consequence thereof, my lord, the charge sheet becomes a null and void document in the eye of law. It will have no sanctity in the eye of law, my lord. Therefore, my lord, if we apply this passage, this eloquent passage from my lord Rizbuth, I will request your lordship to quash on this ground as well. That you don't call it's a table work.
Yes, to after investigation, police has to form his opinion.
Right.
There is ingredients to
constitute the offense.
The offense to
right.
constitute the offenses under section so and so on various sections. Now it is the duty to collect evidence during investigation.
Absolutely.
If it is, if any dead body is recovered after the recording evidence under section 161 CRPC, it doesn't make any difference to the.
But at least there will be an endeavor, my lord. Your lordship is right.
Endeavor.
There will be an endeavor, my lord. But there may not be, the dead body may not be found also, my lord.
There are so many steps in the
right, my lord.
investigation,
right,
but it is not possible in all cases to go through this. Dead body may be recovered after recording evidence,
or may not be also, my lord. May not be.
May not be. It depends.
Maybe mutilated
circumstances.
Also. But your lordship will kindly appreciate this, my lord. I think your lordship will be with me on this. Won't there be any endeavor, my lord, with deepest respect? A. Well, dead body is a general illustration I have given. But in a case which is on document, the police will not see the document. With deepest respect, my lord. But dead body is a general case, my lord. I have given an illustration.
Collect evidence to attract the offences charged in the prima facie case. He has to form an opinion. There is prima facie case under section. I have collected this evidence during investigation. So, police has to form opinion on the evidence collected during investigation. Whether there is any evidence or not, that is to be looked into in the case diary. Next.
So this is the issue, and therefore, my lord, here, despite we placing all these documents before the investigating officer, my lord, there's a charge sheet file. And my lord, regarding the regarding the induction as a director or, my lord, removal therefrom, my lord, this is an issue, my lord, which is essentially civil in nature. My lord, I made that submission the other day because when I became a director in 2004, it was uploaded in MCA portal, my lord, Ministry of Corporate Affairs. So this was in public knowledge. Now, here that complainant is not a rustic person, my lord, who can plead that, look, I was ignorant. So therefore, my lord, your lordship knows, my lord, law is for a person who is vigilant.
No, it is in the FIR that he relied on the.
I'm obliged, my lord. And just to satisfy, since your lordship posed me the question. Right, my lord. Give me the second judgment. I'm obliged, my lord. And
all the matters of the company on his shoulder.
I'm obliged, my lord. Absolutely.
আরেকটা
কপি না দুটো কপি আছে হ্যাঁ আচ্ছা ঠিক আছে my lord, that second one, my lord, out of this
420 406
and forgery, my lord.
406,
20 and 460. I just tell, matlab,
7.
467, 468, 470 or decoration. Now, with deepest respect, kindly let us start. But then, let me start with 420. With deepest respect, who was cheated? What was the misrepresentation? The quintessential element of 420 is misrepresentation. What did I misrepresent? When did you lodge the complaint? The delay? I have placed the other day the judgments where Honorable Supreme Court said if there is inordinate delay and there is no explanation on that ground, we should quash. And recent trend is that with imposing cost, exemplary cost.
1 lakh cost was, yes.
Number 2, my lord, what was, one is delay, 420, 406, what was the entrustment with deepest respect, my lord? Nothing. My lord, I just placed this judgment, my lord. This, my junior insist me, the reason being, my lord, this was from this honorable court where I argued and I lost, my lord. And subsequently, Honorable Supreme Court quashed the proceeding with observation. And here the issue was, my lord, since your lordship raised this pertinent question, my lord, posed me that whether removal or, my lord, adding, induction of a directorship or something of that sort, whether at all comes within the periphery of criminal law. But here there was a trust issue. There's a dispute between the trustees of a trust. One person was allegedly removed. There's a 156 filed. Again, my lord, 4 Jari, 420, 406. We filed a quashment petition at the stage of investigation, my lord, before this honorable court. Initially, Justice Bagchi took up the matter, stayed enter proceeding. Subsequently, my lord, when the matter was taken up by another honorable judge, my lord, long back, after some considerable period of time, the honorable judge said that no, let it be decided after investigation. Then the accused persons who are the petitioner before this honorable court, they filed a special petition before the honorable Supreme Court. The honorable Supreme Court was the proceeding and held that look, whether somebody is removed from the trust or not, all these are trust affairs, all are absolutely civil in nature. And again imposed cost, my lord. Well, this is AIR 2023 Supreme Court 688. Well, I have again flagged, my lord, this portion, my lord, with your lawsuits leave. Paragraph 9, if I may please. Compilation right. My lord has got, my lord, towards the bottom, your lordship will have, my lord, I have flagged for your lordship's convenience. Because prior to that, my lord, the offences were set out. My lord has got, my lord. If I may place, my lord. The materials on record pertaining to the said proceeding instituted in the civil suit produced in the proceeding would reveal that the respondent was in fact ousted from the membership of the trust. In the counter affidavit filed by, my lord, then after some time your lordship will have, my lord, but just after few lines your lordship will have, my lord, that underlining portion there. It starts at the indisputable and undisputed facts admitted in the affidavit and counter affidavit would reveal the existence of a civil dispute on removal of the respondent from the post of secretary of the school, as also from the trust on the trust. Obviously, it can only be taken that since the removal from the office of the secretary and the trusteeship was causative incident, he concealed the pendency of the civil suit to cover up the civil dispute of the civil nature of the dispute. By non-disclosing, the respondent has in troth concealed the existence of a pending civil case between him and the appellants, therefrom from a civil court, which obviously is the causative incident for the respondent's allegation of preparing of the aforesaid offense against the appellant. We will deal with it after further, as also it impacts a little later. Therefore, there cannot be any doubt with respect to the position that in order to cause registration of an FIR and consequential investigation based on the same, the petition filed under section 156(3) must satisfy the essential ingredients to attack the alleged offences. In other words, if such allegations in the petition are vague and are not specific, you also will see not specific with respect to the offense, alleged offences, it cannot lead to an order of registration of FIR and investigation on the accusation of commission of an offence alleged. As noticed herein above, the respondent alleged commission of offences under, again you also will see similar 323, 384, 406, 423, 467, 468, 420, 120B against the appellant. A bare perusal of the said allegation and the ingredients to attract them as adverted to herein before would reveal that the allegations are vague and they did not carry the essential ingredients to constitute the alleged offense. There is absolutely no allegation in the complaint that the appellant herein had caused hurt on the respondent. So also they did not reveal a cause for that the appellant had intentionally put the respondents in the fear of injury either of him or such and such. Then the offenses were described. The same is the position in respect to the alleged offenses punishable under section 406, 423, 467, 468, 421, 20b. The ingredients to attract the alleged offenses referred to herein above and the nature of the allegations contained in the application filed by the respondent would undoubtedly make it clear that the respondent had failed to make specific allegation against the appellant herein in respect of the aforesaid offenses. The factual position thus would reveal that the genesis as also the purpose of the criminal proceeding are nothing but the aforesaid incident, and further that the dispute involved is essentially civil in nature. The appellants and the respondents have given a cloak of criminal offense in this issue. In such circumstances, when the respondent had already resorted to the available civil remedy, here also, there is a civil suit filed. And resorted to the available civil remedy and is pending, going by the decision of civil suit file subsequently. And also they have taken step before, BIFR, AIFR before this honorable court. All, after, registration of FIR. That your lordship will have in the list of that. And your lordship has seen those documents are that. Your lordship has taken note also. Paramjit Singh Batra kindly says, civil remedy has already been availed of. By going by the decision of Paramjit Singh Batra, the High Court could have quashed the criminal proceeding to prevent the abuse of process of court. In the aforesaid circumstances, in the aforesaid circumstances, coupled with the fact that in respect of the issues involved, which is of civil nature, the respondent had already approached the jurisdictional civil court by instituting civil suit and is pending, there cannot be any doubt with respect to the fact that the attempt on the part of the respondent is to use the criminal prosecution as weapon of harassment against the appellant. The indisputable fact that the respondent has filed the pending suit in 2015, he got no case that the OVSJ entered interim order in such and such manner, then it was filed subsequently in 2017. To gather absence of the case, despite such move, he got a right to get informed the affairs of such and such. We are constrained to hold. Then, the 482 petition was allowed. All further proceedings, was quashed by the Honorable Supreme Court. So, removal, induction of a person as a director in a company or a trust is essentially a civil dispute, as was held by the Honorable Supreme Court of India in this judgment. Compilation. Lastly, if I may place, a few judgments I left out from my compilation.
How many judgments?
But it's not required, to be very honest.
Have collected.
I know, my lord.
Numbers.
I do.
You have entrusted him with this.
I do understand. Let me.
Possible to go through.
Even not required. Not required. I tell you, lordship, why I have done so. I just tell you, lordship, why I have done so. I lack confidence in me, my lord, when I see that an FIR was drawn up on a complaint like this, my lord, with deepest respect, despite these judgments. These judgments rule out the position of law which will govern us.
You know the settled position of law. Well, you know well, settled position of law that FIR, if disclosed any cognizable offense.
Right, my lord.
Cognizable, whether FIR discloses any cognizable offense or not, and whether this cognizable offense, if investigation is done, whether sufficient evidence has been collected or not, that is to be looked into only.
Absolutely. Then I will not place, my lord. But I know your lordship,
you are relying on series of documents, so I have to refer all these.
No, not documents, judgments, my lord. But it's not required. But may I eliminate for your lordship's convenience? If your lordship sees the index, let me eliminate, my lord. Kindly seize the index.
Itself. It is not possible.
Kindly seize the index.
Refer all this matter.
Kindly seize the index, my lord.
Yes.
My lord, 1, 2, 3, out of 1, 2, 3, 4, 5, your lordship will only see 4 and 5.
4
Nothing
and 5.
else.
Okay. Then
Malad, thereafter, your lordship will have malad 6 not required, 7, 8, and 9 malad I have given because on suppression, my lord.
Okay.
And in the next page, my lord, only 10 on delay, my lord. And the last one is, my lord, out of 11, 12, 13, 14, either one your lordship may rely.
Either one.
Either one. Because all my lord, the attending circumstances will be.
Okay.
Nothing else your lordship needs to. But I'm so sorry, my lord, the difficult
circumstances, Haji, Iqbal.
all are same, my lord. Only, my lord, what pains me, my lord, despite this, there is an investigational proceeding, there's a charge sheet on these.
Okay, I've seen.
And somebody has suppressed, and my lord, sees from this angle, my lord, before I finish. But despite these judgments, governing the law, my lord, and the field, how could the de facto complainant become so audacious to suppress material facts, my lord, when the law laid down in these judgments, my lord, last 3 I placed, that only on that score the complaint should be proceeding should be quashed, my lord. But that's why I've just relied on. I should not have. Because knowing your lordship, my lord, ideally I should not have relied on a single judgment, 7 Excel Bhajanlal, that too for your lordship's ready reference. How was he so audacious, my lord, to suppress material facts before the court, my lord? My lord, I have filed the written notes. But this is the compilation. I have eliminated those judgments. Your lordship will not look into those judgments.
Okay.
Not required. But I am deeply obliged. I reserve my right of my lord rejoinder after my learned friend finishes, or if your lordship has any query.
Yes. State or me? You. First of all, state will produce only CD. Nothing will be done by CD. I know very well. Start by expressing. Did you prepare written notes? I was waiting to hear it. I'll give it to you.
তোমার দেওয়ার কথা ছিল কিন্তু
Okay, no.
না আমাকে
But first of all, I'm very grateful to Mr. Bhattacharya for today teaching us terms like tectonic shift and magnum fraud. And I'm even more grateful for the submissions he made day before yesterday. Where he admitted that the petitioner was entrusted with the affairs of the company for the company's rehabilitation. Now, my lord will kindly take up his main petition.
তুমি প্রথম বলো সাবপ্রেস করলে কেন
বলো সব বলো But kindly take up his main petition.
FIR?
No, my lord,
এফআইআরটা দেখো না
his petition.
বাইরকে এফআইআরটা দিই
তুই তো 5 বার দেখালি, আমি আর কতবার দেখাবো?
তোমার সাবপ্রেস করলে
আমি turn to page 40. So, my lord, what was the
40 of
my lord, his main application?
application.
My lord, just kindly bear with me for a moment. My lord, in 1999, the company was referred to the Board of Industrial and Financial Reconstruction because it had been sick.
BIFR.
Now, in 2004, my lord, the petitioner enters the scene. Admittedly, why is he here? He is here to rehabilitate the company. Now, my lord, will kindly come to page 40, which is the copy of the extracts of a minutes of the board resolution, which is, my lord, there's a typed copy on the next page. Now, this
48,
at page 40, my lord, will find, even though it's not very legible, at the
48,
bottom,
48.
48. But 40 has been signed. These minutes have been signed by the petitioner. Right, my lord? So, resolved. These are the, my lord,
Extract of the minutes of the
minutes of the board of meeting of the directors of the company held at its registered office on 12th day of July 2004. My lord, of all the, my lord, powers that were, my lord,
given to him.
given to him.
Shudhi Santali, na?
To the
Santali wala.
Satnali wala, sorry.
Satnali wala.
My lord, of all the powers that were given to him, there is no power given to him, my lord, to alienate a single piece of property of the company. Right, my lord? Now, my lord, while the company was, my lord, the reference was pending before the BIFR, the secured creditor of the company, my lord, which is, my lord, the Federal Bank, sorry, my lord, Bank of India, sorry, which, my lord, you will find at page 39, initiated proceedings under the Securitization Act. Now, my lord, when the Securitization Act was, my lord, brought into, my lord, in 2002, when it was, my lord, introduced, there is a section which says that any reference to the BIFR will abate once, my lord, surfacing proceedings are initiated. I'll come to that later. Now, my lord, the bank has a claim of 2.8 crores as a one-time final settlement.
The petitioner claims that he, my lord, organized this 2.8 crores to pay off the creditor. Now, my lord will kindly come to page 41.
Hmm.
This page 41, I have seen, my lord, it's a agreement for sale
41.
of the, my lord, petition. This is an agreement. These are all his documents, my lord, not mine. It is in his petition.
Hmm. Agreement for sale.
Agreement for sale, notarized agreement for sale. This is not registered.
Hmm.
You are saying if it's registered, it's in REM, public knowledge. This is not registered.
Hmm.
And this has been done behind the back of the, my lord, the de facto complainant. Now, I will kindly turn towards the end of this agreement for sale and just see the schedule of the property. I will have to turn to page 72.
Page
Page 72, my lord. The schedule of the property.
'72.
My
Yeah.
lord.
Hmm.
Total area 1,802.5 decimals. My lord, that is almost
Hmm.
20 acres. My
Hmm.
lord, 20 acres of prime land in Sirampur.
শ্রীরামপুরে প্রাইম ল্যান্ড কবে হলো?
Page.
তোরা বড় লোক ভাই, ভবানীপুরে থাকিস, আমাদের now, my lord, we'll see who are the, my lord, parties to this agreement.
Hmm.
That will at page 41, my lord, will see.
Hmm.
My lord, in this document, my lord, this is
Agrawal
done
Steel
completely.
Complex Limited.
My lord, that is the company represented by Sudhir Satnaliwala, not the de facto complainant. A person who has not been authorized, my lord, to deal with the properties of the company. Now, my lord, we'll see the next company, Anjane Ferro Alloys Limited. Next page.
Hmm.
Anjane Ferro Alloys Limited.
Hmm.
The proposed purchaser.
Hmm.
And my lord, he pays a sum of
Director,
rupees.
Subhash Agrawala. Hmm.
My lord, as my lord noted. Now, my lord, this company pays the sum of rupees 2.8 crores. That is, my lord, recorded at page 74.
74. 72. Hmm.
Right, my lord?
Wait.
বিশেষ করে দেন আজকে?
Huh?
কতক্ষণ লাগবে?
Right, my lord?
73.
74.
Yes. Hmm.
What is the amount, my lord? 2.8 crores.
Hmm.
Where has my lord come across that same figure, 2.8 crores? OTS settlement.
Hmm.
One-time settlement with the bank, which he claims he has organized.
Hmm.
He has organized by unlawfully and, my lord, keeping me in the dark, alienating the entire land of the company. And he received 2.8 crores, which, my lord, was paid to the bank.
বাহ, এটা ভালো বলেছো, এটা ভালো বলেছো, থ্যাংক ইউ। তুমি আগে আর্গুমেন্ট করলে আমার বলতেই হতো না কিছু, ভাগ্যিস করোনি।
Right, my
শেষ
lord?
হয়ে যেত সকাল।
Now, my lord, we kindly take up their affidavit in reply.
বার করো, এটা বার করো।
Affidavit in reply. মোটা দেখো।
এইটা। হ্যাঁ, ওইটা।
This is their document. Well, kindly come to page 151.
Yes. 150.
151. This is the registered sale deed that he was referring to. Right, my lord? Now, my lord, we kindly see deed of conveyance dated 31st May 2013.
Hmm.
My lord, my client's signature is nowhere there. Kindly come to page 155, my lord. The parties.
155. Yes.
My lord, Agarwal Steel Complex. My lord, at the top, Agarwal Steel Complex is the vendor.
Hmm.
Anjane Ferro Alloys Limited. My lord remembers that agreement for sale,
Hmm.
2.8 crores.
Hmm.
My lord, this is Anjane Ferro Alloys being the, my lord, confirming party,
Hmm.
represented by Subhash Chandra Agarwal. Now, my lord, number 3, Rovam Vyapar Private Limited,
Hmm.
a second confirming party and represented by, my lord, Akshay Satnaliwala. He is, my lord, the son of Sudhir Satnali.
Hmm.
Then, my lord, a company called Toppers, who again is a confirming party. And, my lord, Priya Foods Products Limited, which is, my lord, the purchaser. Right, my lord? Now, my lord, will kindly see at page 210. Well, kindly come to page 210.
110.
210.
Hmm.
The second confirming party
Hmm.
confirms having received. Who is receiving the amount, my lord? Not the company. The second confirming party, which, my lord, is a company represented by the son of, my lord, the petitioner.
Hmm. Second
Confirming party, which is the company, my lord, by the name of
received from purchaser
purchaser.
rupees.
A sum of rupees 3 crores 70 lakhs towards full and final payment for nomination charges of the sale of said properties made by the second confirming party in between vendor and purchaser in the manner below. So, my lord, what this is just one of the sale deeds.
Hmm.
There are several more. He's annexed only 2. So, what does he do, my lord, the petitioner? He enters into a notarized agreement for sale behind the back of the de facto complainant for 2.8 crores, encumbering all the land of the company, my lord, measuring well over 8,000 decimals. Right, my lord?
Hmm.
This money is utilized for paying off the back. Then, my lord, behind the back, the company with which he had entered into the agreement for sale, my lord, they have another transaction
Hmm.
where the properties of the company are sold to Priya Foods, and the, my lord, sale proceeds are collected not by the company, but by the confirming parties.
Huh.
So the company gets 0.
Hmm.
An agreement for sale which was done for 2.8 crores, one deed shows 3.7 crores. Well, there are other deeds also. I'll kindly turn to page 137.
137.
This is the person rehabilitating the company.
Hmm.
Well, kindly 137 now. The third confirming party confirms. Well, the third confirming party is Rovam Vyapar Private Limited, represented by the petitioner's son. The third confirming party confirms having received from purchaser a sum of rupees 1 crore 5,95,000 towards full and final payment for nomination charges of the sale of the said property is made by
Which
third
property? Which property?
The Sirampur property.
Oh, same property.
Same property. The schedules are before that. If I were to place the document, the recitals are there.
Hmm.
That this company, my lord, Anjane Ferro, entered into an agreement for sale. Now this company is selling off. Anjane Ferro is becoming a confirming party. There is another confirming party who had no role to play in the transactions, but that company is receiving the sale proceeds, not the company who is the owner of the land. And that company, third confirming party, my lord, is controlled by the petitioner's son. Where did all this money go, my lord? I'm asking myself. And what authority you had to sell it?
Page 137. Hmm.
And my lord, what I'm relying is documents produced before this court by the petitioner. It is his, my lord, opposition. Rather reply, sorry.
Hmm.
Now, my lord, he says that he has cooperated with the investigation, supplied all the documents.
Hmm.
My lord, I'll beseech my lordship to take up his main petition once again.
Hmm.
Well,
Yes.
kindly turn to page 95 at the very end, 95. This is the example of his, my lord, cooperating with investigation and supplying documents.
95.
95. Dated 26 June 2015 to Mr. Partho Pratim Das, officer in charge, so and so. This is to inform you that in compliance with your notice under 41A dated Atho, the undersigned,
Hmm.
who met him, my lord, the undersigned,
Hmm.
met your sub-inspector, Mr. Dipti Kumar Haldar, IO and such and such. So, my lord, who met him? The undersigned. And my lord, supplied documents. In another allegation, Mr. Agawala's allegation, Mr. Satniwala, well, the letter.
Hmm.
And who is the undersigned? I will kindly turn to the next page.
Sansaliwala.
No, sir.
Satnali. Huh?
No, my lord. From the office of Mr. Sudhi Satnaliwala, signed by Krishnendu Chatterjee. So the undersigned is Krishnendu Chatterjee, not Sudhi Satnaliwala.
Hmm.
So this was their cooperation with the investigation.
Hmm. Hmm.
But this is regarding the land at Siram. Now, my lord, as far as land at my lord, the land which was at my lord Paharpur,
Hmm.
at the time of lodging the FIR, some information was not there with the informant.
Hmm.
Now, yes, it appears that there was an order passed by my lord, the board, and the land was, my lord, taken back. Very good. Land was taken back. What about the plant and machinery which stood on the land?
Hmm.
Where did that go, my lord? I'm asking myself. Land is taken back, but admittedly there was a factory on the land.
It was leased.
Leased land, but there was a factory on the land.
Hmm.
That was the property of the company,
Hmm.
not my lord, the port trust.
Hmm. Hmm. Hmm.
That is gone. Now, as far as the registered office is concerned, why, my lord, we said that we are sure that some documents have been forged, because, my lord, this rented premises since 1970s used to be the registered office. Now, my lord, registered office under the Companies Act is very significant. Registered office, to change the registered office, you will have to have board resolutions. You may also have to have an AGM. I was never present. I was never invited. So therefore, my lord, I have, my lord, reasonable grounds to suspect that board resolutions were forged. Now, it is for the investigating agency, my lord, to discover that. That is why we had said that. But I'm not on that entirely. What I'm on, what has not been shown to my lordship, is this notarized agreement for sale, done completely behind the back, with no authority. A person who's been inducted and entrusted with the properties of the company for, my lord, the rehabilitation of the company. What does he do? He enters into, my lord, a clandestine agreement for sale with somebody he knows, collects advance against the entire land of the company, or 20 acres of land of the company, uses that money to, my lord, repay the bank. And the bank then, my lord, the surface proceedings are, my lord, withdrawn. Now, this was the question of law which was troubling all of us. At first, there was a reference to the BIFR. When there is a reference to the BIFR, there is an automatic, my lord, stay in, my lord, dealing with the properties. But as soon as surface proceedings are drawn up, my lord, the reference will abate. Right, my lord? So now let us visualize. There was the reference to the BIFR. I could not have sold. once the bank steps into the picture, initiate servicing, reference is abated. But once the payment is done to the bank releases the charge, we go back to status quo ante. That was our, my lord, contention before the BIFR, then the AIFR, where we lost, and then it was pending. It is still pending before this honorable court. And my lord, they have, my lord, the last order that is still pending adjudication. Now, the question there was, my lord, if the sale was made while the reference to the BIFR had abated, but then again, my lord, it is back to status quo ante, whether the sale made is, my lord, lawful or not. This is definitely not a criminal matter. It is a matter of civil nature, my lord, which is before the writ court. We are not on that. All I am saying, my lord, we kindly read the FIR without reference to the, my lord, the AFIR, BFIR, for the time being. And then let us see whether, my lord, the offence is made out of it. Now, my lord, during the investigation, my lord, we have stated that we are also not very happy with the, my lord, result of the investigation. And my client has been advised, my lord, to prefer an RIG petition, but we couldn't because of this case being pending. Now, during investigation, I have showed to my lordship how they have cooperated. The undersigned has met you in compliance with 41A. The undersigned has given you so and so, and this undersigned is not the petition. Right, my lord? And my lord, as far as, my lord, the stellar background of stellar background of, my lord, the petitioner is concerned, my lord, if you take up our affidavit in opposition, my lord, page 17, our affidavit in opposition. So,
একটা abandoned হয়ে
একটা abandoned হয়ে গেছে।
একটা ওরা সব অ্যাকসেপ্ট করে নিয়েছিল, আমরা ঠিক বলেছি এইটা বোধহয় দেখি।
তুই ঠিক বলে তা কে বলবি?
তুই স্টেটা তো এখনো পাইলটকে বললি না?
সব বলে। তুই বস না, তুই এত হাঙ্গামা করছিস।
এটা?
This is the, my lord, track record of the petitioner. It's the complaint referred by a chartered accountant. This is admittedly unconnected to the present FIR, but I am showing this, my lord, to show, my lord, the track record of the petitioner. This is to bring to your knowledge that I have obtained the certified copies of balance sheets of the under-mentioned companies filed with the Registrar of Companies, Kolkata, in various years over the last 10 years. All the said balance sheets have been filed with my signature or firm's name and seal as the alleged auditor. I hereby inform, to the best of my knowledge, belief, and information, I do not know about any of these companies, nor do I know Mr. Sudhir Satnaliwala or Mrs. Kalpana Satnaliwala, who have been filing the documents at the office of the Registrar of Company, Kolkata, with the forged, used my name's firm's name, forged my seal, and forged my signature. Now, there are 1, 2, my lord, 55 companies. This petitioner and his wife have been submitting, my lord, audited balance sheets of 55 companies with the forged signature and stamp of a chartered accountant for the last 10 years. This is what he is capable of doing.
Where is your company?
My company is not here.
It's not connected to
I am
this
saying
case.
it is not connected to our case. I'm saying. But all I'm trying to point to a lordship is this is the track record of, my lord, the petitioner. Satnaliwal, whatever his name is, you forget.
Item number is his information. Here we inform that my knowledge, belief that I do not know about any of these companies. Nor do I know all the ministers so and so from here. They have been filing the documents at the office of the registrar with regard to names of this company are as follows. Oh, in the name of these companies?
No, our company is not there.
Not there.
All I'm trying to show, my lord, is that this.
No,
this
what did he do?
My lord, he has forged the, my lord, and my lord, the all limited liability companies, my lord, need to have, my lord, audited balance sheet.
But he wants to show that I am a bad man.
You are. Now, please take your seat.
No, I am not. That you are. You have
He has filed
He has, my lord, he has been uploading on the
Satnalia,
website,
Satnalia
has
filed
been
the audit
uploading
reports.
audit reports with the fourth signature of this auditor. 55 companies for 10 years. Now I will kindly turn another complaint against him.
Hmm.
Or by another chartered accountant. Page 20. This is the second complaint against him.
Hmm.
Now, my lord, kindly turn to the next page. This complaint by a third party addressed to, my lord, the police reference is Alipur PS DD case
Omar
number
Pal
120 dated
is Kohli.
8/6.
Mr.
Kohli,
Omar Pal is Kohli.
Yes, my lord. 9 crores 90 lakhs embezzlement. So this is the person we are dealing with. Now, my lord, kindly come to page 128.
Hmm. Hmm.
128, my lord. Why there was this confusion? Whether the reference is pending, not pending, my lord?
125.
128, my lord.
8.
A copy of an order dated on 26/7/2016.
Hmm.
Mr. Mitro Lanet, Senior Counsel appearing for the petitioner, submit that the respondent number 2 did not have the authority to file a petition of appeal before the appellate AIFR. He further submits the board of BIFR has directed status quo ante.
Hmm.
My lord, I told my lordship, submitted my lord, once the bank gets into the picture under SURFACE, BIFR reference will have it. But what happens when the bank, my lord, withdraws the SURFACE proceedings upon being satisfied with my lord the repayment? Has directed status quo ante, retrieval of properties in favor of his client. The appellate authority has illegally overturned the order. Mr. Mukherjee Lanet, Senior Counsel appearing for the respondent number 2, submits that the appellate authority rightly set aside the BIFR order of the BIFR in view of the fact that the property had been disposed of under the provisions of the SURFACE Act as secured asset, which is not true. This secured asset was not sold by the bank. This, however, is disputed by the learned senior counsel for the petitioner. In view of the nature of the dispute, I am of the opinion the issue is required to be decided upon exchange of affidavits. Affidavit in opposition filed 4 weeks, be filed 4 weeks hence. Reply thereto, if any, be filed 2 weeks thereafter. Matter be listed under the heading final disposal 6 weeks hence. In view of the rival claims of the parties on the property in question, and in order to avoid creation of third-party interest therein, I direct the parties are restrained from creating any third-party interest in the property without the leave of the court. Interim order shall continue for 10 weeks or until further orders, whichever is early. So, the confusion that was created, that will be answered by our honorable court. Admittedly, there was a reference to the BIFR. Admittedly, statutorily, my lord, if there is a reference, then you cannot deal with the assets of the company. But here the peculiarity is, my lord, once bank in my lord, decided to enforce, my lord, this SURFACE Act, my lord, then it will automatically abate. So what if some properties are sold? What if some properties are sold while it has abated? The BIFR subsequently said, no, you will have to restore the property. The AIFR ruled, no, you don't have to. The sale is okay. Our High Court is to decide. That has got, obviously, there is no criminality here. It is a different question of law. Facts are the same, but the law that applies is different. Here, on the set of facts I have, my lord, placed before my lord, what has been stated in the FIR, my lord, the charge sheet is not in my control. The FIR is in my control. I am saying I am unhappy with the investigation. I am saying that I have instructions to, my lord, prefer an RIG petition, but I cannot unless this application is disposed of. And here, my lord, what he's done, admittedly, he was, my lord, assuming he was appointed director. Whether I said you please don't use it now or don't, I understand. I have signed the Form 32. I have admitted signing the Form 32, and I have admitted entrusting him with the affairs of the company for the company's, my lord, rehabilitation. But my limited knowledge of English, my rehabilitation doesn't mean stripping the company of all its assets behind the back of the shareholders, other directors, and then pocketing the proceeds. Well, I could have understood that the land has been sold. The land has been sold. The money is come into the accounts of the company. I could have understood. Here, the money comes in the pocket of a third confirming party, which had no role to play all through. Malat, I can understand that company, which was the Malat, purchaser in the agreement for sale. That company is given 2.8 crores. That company being the confirming party, I can understand. That company receiving the Malat, proceeds, I can understand. But the second confirming party, third confirming party, well, they're complete aliens. Aliens controlled by the family of Malat, the petitioner. Our 120B was to rope in all these persons, but investigating agency has not filed the charge sheet against them. So therefore, we will file an RRG. So a person entrusted with the assets of the company to rehabilitate the company, my lord, first enters into covert clandestine agreement for sale notarized. I could have understood if it was registered. A notarized agreement for sale collects 2.8 crores, uses that money to pay the bank, claiming he's arranged it. Once the my lord, assets are free, then my lord, he enters into my lord, registered agreements with my lord, Priya Industries, whatever. And my lord, I have
When the sale
2014. We got to know later on. And these toppers, this company called Toppers, they had their board there. So when the de facto complaint was informed, look, there's something going on with your land in Srirampur, he went to inspect. And he finds that his company's board is gone. And there's a board of Toppers, whatever, which is controlled by petitioner. So all the assets of the company, my lord, 30 acres of prime land in Srirampur, my lord, sold to a person, and the entire sale proceeds collected by companies controlled by his family. So, my lord, this is the rehabilitation. Well, what was he saying? Well, what fraud? Ki boldi? But this is, my lord, the position. And Paharpur, as I said, my lord, if it's the Paharpur land was surrendered by a purported, my lord, quasi-judicial order, fine. But where did the, my lord, plant machinery go? I'm asking myself. And my lord, he annexed the, my lord, the board resolution at page 40A, 41A. He has annexed the board resolution. And my lord, I do not see him being authorized to, my lord, deal with a single piece of property of the company. So when he's entering into, my lord, a agreement for sale or the my lord, registered my lord, deeds of conveyance, and he's introducing himself as the authorized signatory, that's a false statement, my lord. He's not authorized. He's only authorized to, my lord, do the, my lord, or rather, my lord, take up the tasks which are there in page 40 and 48. When did you become authorized to, my lord, to enter into an agreement for sale, or, my lord, to be a confirming party to, my lord, a vendor to, my lord, deed of conveyance? So those documents are false documents, my lord. That's all, my lord.
So you have to file, you have to,
I'll file the written notes, my lord, by day after tomorrow. I'll hand over, my lord, with copy to my lord.
when you will file, then
Day after tomorrow, my lord, I'll hand over to you, my
My
lord.
lord, I'll give my reply. I'll just take 10 minutes any day, my lord. I can take tomorrow, day after, whenever it's convenient.
যেদিন ওই রিটেন নোটসটা দেবে আট করে দিতে পারেন বাবু
তোমার কিছু
হবে না
হয়ে যায়
হবে
বললাম
হ্যাঁ হ্যাঁ
কি বলছো কবে কালকে
কালকে পরশু
শুক্রবার কখন
12টা একটা আছে
12টা দরকার নেই আমাদের ফ্রাইডে ইউর লর্ডশিপ ইজ ফিক্সিং ইট my lord.
Friday already fixed 12 and one
Well, I'll just take 15
one
minutes my lord.
original side matter is also fixed on that day at 2 p.m.
No, my lord, it's in
Two.
first half my lord, if I get my lord 15 minutes I'll finish it off. Quarter to 1 I can come my lord.
First half রেখে দিন assignment পরের দিকে দিয়ে দিন তাহলে
এইটা কি কবে
না টাইম ফিক্স করা
কোনটা?
যাচ্ছে না।
কখন
কখন তোমার
আচ্ছা ঠিক আছে
We are appearing on behalf of the state. Would you like to advance any argument?
Mr. Panda is leading me, madam. Give me letter.
When?
Madam, next week.
Then it will be question of reply by you.
right my your lordship is right my lord.
Madam, instead of Friday, madam.
But next week I have some difficulty the entire week I will not be here.
হ্যাঁ 19 তারিখ হবে না 20 তারিখ করবে হ্যাঁ
Thank you.
19th
Malu.
will you will
He has
submit
finished.
Or I'll
He's
just
only
hand
stayed.
over.
then I will submit the
I think beforehand he can give me an advance copy.
I'll give you an advance copy.
Perfect.
Malu,
and you
19th,
will argue
19th will hand over Malu written notes to Malu.
let the matter hard line counsel appearing on behalf of the parties let the matter appear on 19th February 19th at 12
Most obliged.
19th আছে না এইটা রাখুন ভালো করে। তারপরে দেখবেন adjust করে
Take your lordship's leave.
হ্যাঁ
Deep level.
I will take up one matter at 2 p.m. Then will come. I will.
Before rising, Lordship, item number 19, please read. Your Lordship, please to observe, go out of list, because as per the learned advocate for the petitioner, that one hearing co-sharer of section 8, preemption matter is pending before the higher bench.
It has already been observed by the earlier court, earlier
Yes,
bench.
Your Lordship, I have showed before your Lordship yesterday that they have not pressed these grounds before the learned trial.
Is it so?
Also, I have shown before your Lordship yesterday, that they have took time.
Oh.
Today I have absent so much. They, in the meantime, they have prayed for and Lordship.
Mention it tomorrow.
Lordship, kindly,
First
for
day.
this week in the meantime, I serve notice. Lordship.
Call him. I'll be coming at 2 p.m.
Lordship, he is not.
Just inform him.
My phone calls, both the phone calls given in the repetitions are out of order.
এই দেখুন তো পাওয়া যায় কিনা করে দিন কালকে
Yes.
to be mentioned করে দিন to be mentioned চলে দিন নট পেস করে দিয়ে ওই ইস্যু